The Senate is back in order. We are on the second agenda item, order business number 4, reports of committees.
Mr. President, your Committee on Commerce and Labor, to which were referred Senate Bills numbers 145, 167, 203, 249, 270, 283, and 381, has had the same under consideration and begs leave to report the same back with the recommendation amend and do pass as amended. Signed, Senator Pat Spearman, Chair. Mr. President, your Committee on Government Affairs, to which were referred Senate Bills numbers 81, 115, 166, 208, has had the same under consideration and begs leave to report the same back with the recommendation amend and do pass as amended. Signed, Senator Edgar Flores, Chair. Mr. President, your Committee on Health and Human Services, to which were referred Senate Bills numbers 41, 117, 237, 239, and 380, has had the same under consideration and begs leave to report the same back with the recommendation amend and do pass as amended. Signed, Senator Fabian Doñate, Chair. End of reports.
Thank you. Order of business 8, waivers and exemptions.
Notice of exemption, April 17th, 2023. The Fiscal Analysis Division, pursuant to Joint Standing Rule 14.6, has determined the eligibility for exemption of Senate Bills numbers 41, 88, 166, 167, 176, 232, 237, 241, 297, 311, 380, 387, and 428. Signed, Wayne Thorley, Fiscal Analysis Division. End of notices.
Thank you. Order of business 9, motions, resolutions, and notices.
Senate Joint Resolution 7, introduced by Senators Cannizzaro, et cetera, and Assemblywoman Howdigy, et cetera, proposes to amend the Nevada Constitution to establish certain rights relating to reproductive health. The people in the state of Nevada, this is a resolution. End of resolution.
Are there any amendments to the joint resolution?
There are none.
Thank you. Are there any remarks from the floor? Senator Cannizzaro.
Thank you, Mr. President. I stand in very strong support of Senate Joint Resolution number 7, which proposes to amend the Nevada Constitution to establish certain rights relating to reproductive health. As many of us know, last July, a very radical Supreme Court wiped out 50 years of legal precedent, which is frankly unheard of. As a lawyer, you just don't see courts wiping out precedent because it is the very basic fundamental tenet of how it is that we structure so many of our laws. Legal precedent is what drives so many decisions, not only legislatively, but also judicially. It's a guiding principle, and so to see precedent stricken for no new reason whatsoever, that also had the immediate effect of stripping health care from so many Americans, leaves us in a place where I don't think that we, even as the state of Nevada, can ignore that as a reality for so many of us. There were very long understood rights associated with the Roe v. Wade precedent that was stricken by the Supreme Court in the Dobbs decision. The fundamental right to privacy that allowed for women to seek an abortion and to seek reproductive care in so many ways was simply stripped from them. And those are medical decisions. Those are medical decisions that should rely on a woman and her provider to make. Since then, not only have we seen that particular court decision take place, but we have also seen states, even states surrounding Nevada, take immediate action to wipe out any right whatsoever for a woman to consult with a medical provider to provide the best care for her unborn baby, and for any other attendant reproductive care. It's not just limited to whether or not someone may seek an abortion. It's also limited to what decisions you make about when and how you want to create a family, about how you may go about that, if you may need the services of IVF or fertility treatments, about whether someone can access and use birth control, about whether we can even have a discussion about reproductive health care. Instead, what we should do is just ignore that it actually exists and continue about our business. And for me, that's just an untenable place to be. When we talk about reproductive health care, it's so much more extensive than that. And something like the Dobbs decision we have seen doesn't just touch whether or not a woman should have the choice to seek an abortion. It is now also touching, and if you haven't read some of the headlines, I would encourage my colleagues to just take a quick Google search. It is touching birth control. It is touching access to that. And it is affecting whether or not we are even going to continue to have providers to provide care, no matter what your choice may be. In so many places, what is important, I think, for Nevadans and for this body to keep in mind, especially as it relates to Senate Joint Resolution number 7, is that there has to be one guiding principle in this, and that is that politicians should not be interfering in personal decisions between patients and their doctors when it comes to reproductive care. There shouldn't. I do not want anyone in this body to help me make decisions about my current status as an expectant mother. That's not your business. It's my business, my doctor's business. And the ability to continue to access reproductive care should be a fundamental right. It should be a right that everyone has, that is protected from the overreach of politicians trying to tell us when and how we should do things with our bodies and how it is that we should make decisions about how to grow or not grow our families, about how it is that we may continue to access this type of very essential health care. And I believe that the voters of Nevada would agree that that's a decision that they should make, that that's something that they can, and that I trust that they can, make a very coherent decision on for themselves and for their families. Now, we've heard so much talk about, in Nevada, this is not a worry, this is not something we have to consider. We have a statutory protection to abortion specifically, not to some of these other things, but we've done other statutory provisions to ensure that there's access to reproductive health care. But what we are seeing, and this is very real, and unless you want to ignore it, is that there is absolutely an effort to strip any of those decisions away from whoever needs to make them for their own personal bodies. And that affects Nevada the same way. Also, I would note that these are statutory protections. And as much as I have been a member of this body, I feel as though we have had a lot of discussions about what the difference is between a statutory protection and something that is a fundamental constitutional right. Statutory protections can be changed by this body. That is our job. We enact statutes. We have voted on many pieces of legislation today to change those statutes. Should they make it through the entire legislative process, that change is what the law is. Now, granted, this particular 1990 statutory provision is a voter initiative, so it requires a bit more steps to change, but do not misunderstand that that does not provide reproductive health care freedom. That's not what that is. It doesn't provide a right. A constitutional right, and something that is a fundamental right, means that we say we believe in this right. And then if this body wants to change the law that so much as touches or abridges that right or affects it in any way, then a court, upon review, can say, well, does it meet the test of strict scrutiny? Do we believe that this is as narrowly tailored as possible to meet a very compelling government interest? i.e., should the government be allowed to have any sort of piece of this? And if so, did the pieces that they put in place, how they were fashioned, did it address that very compelling interest in the least restrictive means possible? But what that means is that that right doesn't get changed because a statute came into place. It means that someone can rely on that to say, you know what, I have this right. And so if we pass a statute that were to say limit the ability for individuals to access fertility treatments, to access birth control, to access other reproductive health care, then they could challenge that and say, look, my right is important. And we do this in a number of ways. This is the same as the right to free speech. Right? It's a fundamental right. There's a reason why that's important to have in a constitution. There's a reason why we're not talking about let's strip that from a constitution and just put it into a statute, because they're different. And for me, and for anybody who's ever had to make healthcare decisions of a reproductive nature, be that with a partner or on behalf of yourself, the ability to make that decision should be, and the considerations for that decision should be, regardless of what that decision is. And you don't have to agree with what somebody's decision is, and you don't have to make the same decision that they made. But what should be fundamental is that that decision is only between that individual, their family, and a medical provider. I don't want to have to make those decisions any other way. And I think that Nevadans don't want to either. And the important thing, I think, about Senate Joint Resolution number 7 is that this gives the voters of Nevada a chance to make that decision. I trust them. They're the people who sent me here, people who sent all of us here, and I trust them. And I trust that we should give them this particular decision. Now, we've heard a lot of things. This is going to mandate that people have to get certain care, that you might have to have an abortion, or that a provider would have to provide an abortion, or that this is somehow going to change the status quo of Nevada law, and we're going to be seeing all kinds of crazy things. That is not what this is intended to do. This is intended to put in place something that we thought really was a fundamental right up until this last summer. This does not require a provider to provide an abortion. This doesn't require anyone in Nevada to make a particular choice. This does not change or abridge current statutes. It says we have a fundamental right. And then, if there are any statutes that might touch on that, we know that what we're going to be guided by is that very principle, which, by the way, is exactly how so many of our rights, anything that's in the Constitution, or that has been delineated by a court to have a particular right to some particular thing, that is how we are driven. And for fundamental rights, that test is strict scrutiny. And I would also remind this body that the other statutes that we have passed were also passed in a time where there was 50 years of legal precedent relating to both access to things like birth control, access to abortion, and to reproductive care, where that was a solid right, where that was something that was undisputed, and where we've even had conversations about other pieces of legislation in this body where it says, well, Roe versus Wade is the law of the land, and so we don't have to worry about this necessarily because, that's the law. And it turns out it's not. And so we have to do something to address that, because there are too many people who are not going to have access to health care here in Nevada without it. And again, this is not a decision that we're all going to make today by passing this. We're going to say, look, we should send this to the voters, and they should make that decision. If they say no, then they say no. If they say yes, and I would venture to guess that voters in this state believe that they should and do and want to have that right, then that's something that the people who we all represent here in this body want us to do. And if we believe that them sending us here to represent them is sufficient, then I think it should be sufficient for them to say whether or not they believe they have access to this fundamental right. So, Mr. President, I would urge my colleagues to vote yes on Senate Joint Resolution number 7. Thank you.
Thank you. Senator Severs-Gansert.
Thank you, Mr. President. I rise in opposition to SJR 7. We've heard a lot about the Dobbs decision, and the Dobbs decision was the U.S. Supreme Court that basically deferred to the states to let them govern this issue. It didn't eliminate the right to abortion. It said the states get to govern. So I want to make sure that that's clear first. And in our state, we have the Freedom of Choice Act that was passed in 1990. So that was 33 years ago, where a woman is able to have an abortion up to 24 weeks. And so this is a significant change. And I can tell you some anticipated that maybe there would be a proposal for a constitutional amendment, but not an amendment that had a list of all sorts of different things, from infertility care to different, all sorts of things on the list. I have to get it closer because I can't see that far. Vasectomy and fertility care, things like that, and some things that you wouldn't even expect to have to make a right because we already have them, and you have the freedom to choose that whenever you want to. But now we have a resolution that's trying to make them a fundamental right. And again, we had voters pass the Freedom of Choice Act back in 1990. And I want to, and Nevada is different than other states. We are seeing in different states more restrictions on birth control, but we've been going the other way. Nevada is different. If you were to look back to 2017, we had Senate Bill 233, which expanded dispensing of birth control to 12 months. If you look to 2021, Senate Bill 190, we allowed pharmacists to dispense birth control. And this session, we have Senate Bill 280, which would allow the dispensing of birth control to minors without parental consent. So Nevada has been going the other direction. So in my mind, there's just not a threat to a lot of the things that are on those lists because we've never had an issue with that. So this resolution is extremely expansive. And if you look to the bill itself or to the resolution itself, there's several things that are in direct conflict to what we have in statute. And when you have a constitutional amendment, you have the higher scrutiny. You have strict scrutiny. So if you were to look at section 25(2), it talks about after fetal viability that someone can have an abortion because of physical or mental health, because of their issues around physical or mental health. Well, mental health is very subjective, and when you look at the broad language, there's no time restriction. So if you were to look at our statute, 442.250, that's where we have in statute the limitation of 24 weeks. And that statute is an affirmed statute, so it actually takes the vote of a people to change it. So that 24 weeks is secure in our statute, yet we have conflicting language in this resolution. And then if you were to look at section 25(4), it talks about informed consent. And I can tell you the first version of SJR 7 included informed consent, but then it was amended to make it voluntary consent. So we've gone from informed consent to voluntary consent. That conflicts. Then in statute 449.191 right now, we have moral objections. So if someone doesn't want to participate in abortion, if they are a healthcare provider and they do not want to participate, they don't have to. Nowhere in this resolution is there a moral objection criteria. So the language of this resolution is very broad. It conflicts with current statute, and I know we've had conversations in committee about, well, this is a resolution, it's a constitutional amendment, it's strict scrutiny, and then basically you have to go to the courts to see what happens with your statute. Well, we know with strict scrutiny, what's in statute does not take priority. So when we see you have going from informed consent to voluntary consent, when you look at some of the other changes in language, especially the moral objection, it just doesn't even exist. So we believe that this resolution is far-reaching. The language is extremely broad and should be rejected by this body, and we would expect it to be rejected by the voters as well. I appreciate everyone listening today. I think this is going to be an ongoing debate. And again, we had a Dobbs decision that deferred to the states. It was about abortion and deferring it to the state, that issue, and now we have a resolution that's very expansive, and I think we really need to question it because we do have statute that's a firm statute around 24 weeks, and we also have other statutes that actually expanded birth control, statutes that made sure there was the ability to have a moral objection and other things that I think are really important to people. So thank you for the time.
Senator Neal.
Thank you, Mr. President. I rise in support of SJR 7, and I really feel strongly about what I'm getting ready to say. SJR 7 hearing drew deep emotion from me. I watched the brutal hearing. I was distraught over the policy, and it brought back flashbacks of when my mom and my dad fought over abortion rights in my house while he served in this Senate chamber. I was 12. He believed in choice. My mom believed in the right to life. And I don't believe that anyone has the right to play God or to be God. And I bring this up because there's context to my voting history. The hearing also brought up flashbacks of my past that has never been discussed in this body or with anyone outside of my family. That when I wanted to abort my child, my mom, who was a devout Catholic, said no and said I needed to give my daughter up for adoption, which I did not. And I'm grateful that I didn't. But what's important in that conversation was that I was grateful for the choice and the time to think about what I was going to do and decisions I was going to make for my future. I read the news now, and I see the stories of people fighting back and forth. And I support choice, but it has two sides. I support a person's faith, and I support a person's ability to choose for their own health, safety, and welfare. SJR 7 is difficult. It draws a line in the sand, but it makes the fight to be had by the voters. I had trouble with defining the viability of a fetus in the Constitution. By defining it, I felt we were removing another side. However, I weighed the pros and the cons. I weighed the liberty interest to fight over the right of citizens to decide for themselves what they felt should be allowed into the Constitution. I grew up with Wade, so I never had to examine its loss. However, I had to examine its loss now. I had to examine, is this a liberty choice? I reviewed Roe versus Wade, which examined the Ninth Amendment and whether unenumerated rights exist outside of those expressly protected by the Bill of Rights. I reread James Madison's intent, a founding father of the Constitution, who wanted to ensure that the Bill of Rights was not seen as granting to the people of the United States the only specific rights it addressed. So I examined it through the lens of rights, the lens of protection, and through the lens of the Constitution. My emotional heart, my spiritual heart was torn because I know that as humans we face deep choices and complex issues. Life is something we should debate over, but it should also be weighed against the liberty interest and the choice of the individual. It is a powerful place to decide whether to terminate your own life or the life of another. I grieve for the women who still have to make these choices because it is a burden that you carry forever. But I stop short at denying the right of citizens to battle at the ballot box over this issue. I will probably be on the other side of the ballot box, but as a leader in my district, I believe that they should have the right to fight for their beliefs. And I expect that the day that this is on the ballot, that we will all have to come to a reckoning in Nevada about what exactly that we stand for and what we believe. And I'm hoping that we will find the balance between faith and choice, that we will find the balance between God and what everyone else believes, which might be the opposite of that. That SJR hearing, I listened to those people come in both sides, but all I wanted was balance. All I wanted was to eliminate the fighting. But I understand, after talking to my own daughter, who talked to me about her choice for the future and how I was able to make my own choices as a young woman, that I needed to enshrine her ability to go to the ballot box for what she believed, not for what I might have had the power to vote on in this body. And so I wanted to make that statement because I have had a mixed voting history around abortion rights. But this particular measure is an allowance to go and let the citizens of Nevada decide one way or the other if it's going to be a part of the Nevada Constitution, and that I support. Thank you, Mr. President.
Thank you, Senator Hansen.
Thank you, Mr. President. Like my colleague, this is a highly personal issue for me as well. You see, I was conceived in 1960, and my mother was 15 years old when I was born. 3 of my 4 grandparents sought aggressively to find an abortionist. Fortunately, at that time in Nevada, There wasn't one available legally. And I stand here before you today as what would have been had I been conceived after Roe versus Wade, an aborted fetus. So when we discuss these things, you know, we seem to be talking almost like there's not a third party in this equation. If we go back in the United States history from 1776 to 1865, we had a huge debate over slavery. But you'll notice as we look back, there was one enormous section of the society that was not included in the debate, and that was the slaves themselves. So when we had the abolitionist movement starting in the 1830s, clear up to the time of Abraham Lincoln, when Abraham Lincoln was elected, the Democratic Party had split three ways between Bell, Breckinridge, and Douglas. Abraham Lincoln, who is known today as the great anti-slavery president who got the Emancipation Proclamation, he was elected in the United States with 38% of the electorate. 38%. In other words, 2/3 of the people of the United States supported slavery. Now, while I respect the idea that we're going to put it on the ballot and allow people an opportunity to vote, I think we have to recognize clearly that we are leaving the most significant portion of the equation out. There's nobody speaking for the unborn. Now, the viability question, I'm going to address that. But first, you know, for those of you that come up by my office, you'll notice on the inside of my door, I hang these little plaques, and I move them every day. And this is one of my most popular, one of my most famous. This is a picture of Booker T. Washington, who in my opinion was the greatest black leader in American history. And he had a famous quote. In fact, underneath this picture, you see it says majority rule. And this is what Booker T. Washington said. A lie doesn't become truth. Wrong doesn't become right, and evil doesn't become good just because it's accepted by a majority. So yeah, this may pass with majority vote, but guess who doesn't get the vote? The very babies who are going to be aborted, including, if it had been in 1960, myself. Now, the question of viability. This is a fascinating one to me, that this is actually in the Constitution, because the age of viability has gone back. You know, we always talk about best available science. You know what the best available science is? We're becoming able to save babies earlier and earlier. And as you know, I'm very blessed. One of my daughters right now is pregnant with twins. And we got to watch on an ultrasound or sonogram or whatever it's called, those little babies in there, and they were about 12 weeks, and you could see them kicking and moving. You could see their face and their hands and their feet, and they were as live as you and me in the environment that they were in. None of us in this room are viable outside of our environment. You could take me right now, and you could throw me into a body of water and hold me under that water, and in 10 minutes, I'd be dead because I'm not viable in that environment. Now, we wouldn't have to have an abortion if they weren't viable. What the heck are we doing here? We are actually stopping something. We talk about playing God. If we leave that baby alone in the womb, what does it do, die or something? No, it is totally alive. It is doing just fine in the environment that it's designed for. And if we don't abort it, it will come to full term and be born and become one of us. Interestingly enough, once it comes out of the female's body, then it becomes something that we protect. Everybody in this room talks all the time about we need to protect the children. You're right, we do. I'm just saying we should extend that to where they are viable inside their own environment. For some reason, that portion of this equation is being ignored. And just as the slaves that were in the United States and were legally property and denied the right to vote and the right to be able to have any say in the debate over whether or not slavery was morally right or wrong, they were denied the chance. And right now, guess who's being denied the chance to discuss the very issues we're talking about? Because I got news for you. Those babies are totally viable. They are growing. They are healthy. And in the miracle of science, we can literally watch on a sonogram or an ultrasound and watch that baby kicking, moving. Look at its fingerprints. By the way, at the age, I think it's 8 weeks, they have perfectly formed fingerprints. At 6 weeks, they've got a perfectly developed heart, which is pounding away. You know, if you and I came to a car accident, one of the things that we would determine whether or not somebody is alive or not is, do they have a heartbeat? Anybody in the medical community would say, yeah, of course, that's when you know if somebody's alive or not. A baby at 6 weeks, this is usually about when you typically discover whether or not you are even pregnant, has a fully pounding heart. So I don't know, I understand, I really am sympathetic to people in these positions where they have to make these kind of decisions, but I'm exceptionally worried that the people that are most impacted, the unborn children, have no say in this matter. And to put this in the Constitution means that if in the future a legislative body does, with advances in medicine and everything else, want to modify some of this stuff, we put handcuffs on them. By putting that in the Constitution, as we all know, that is generally we don't want to do that because there are reasonable reasons to adjust all sorts of laws. We're constantly coming back in this building and changing things. But once you put it in the Constitution, then that's pretty much, it takes our hands out of it completely. So while I do respect the idea that these are personal decisions, please keep in mind as we go forward, and obviously this is going to end up on the ballot, as we go forward, that just like in the old slavery days, don't forget that there's somebody else in this equation who has no voice in the decisions that we're going to make, and who frankly deserve it. The evidence is so overwhelming that these are not unviable tissue mashes like somebody still tried to tell me the other day. These are living, breathing human beings in an environment that they're perfectly capable of continuing to live in, and we should at all costs, I don't care what the majority, the citizens of Nevada say, frankly, because I don't believe majority rule in every single case is correct. Just as our ancestors, to our shame and discredit today, they supported slavery. 2/3 of them, as late as 1860, were still in favor of keeping people enslaved. And guess who didn't get to vote? The slaves. Guess who doesn't get to vote on this? The unborn children. Same exact principle. Please, as we go forward with this, and I assume it's going to pass, probably party line, as we go and put this on the ballot, keep in mind that we're talking about a human being every bit as live and viable as you and I sitting here right now. Thank you, Mr. President. I urge my colleagues to vote no on SJR 7.
Senator Stone.
Thank you, Mr. President and colleagues. In my almost 8 weeks of being here, I have to say that I'm very impressed with this institution, that we can have debates in committee, we can have debates on the Senate floor, and we can do it professionally, without personal attacks, and agree to disagree. And so I want to thank all of you for welcoming me here into this legislature, knowing that we're not going to always agree on everything. And I really appreciated the comments from the majority leader, the senator from District 4, and my colleague in District 14. I have to be honest, I'm very concerned about this amendment. This is my 28th year of being an elected official, and I'm very proud to say that I've been pro-life all 28 years. But I also, in contrast to maybe some that are in the pro-life movement, believe in exceptions. I believe there's an exception for incest, for rape, for the health of the mother. My worry is that the health of the mother is very vague in SJR and would allow a woman to use something that may not be life-threatening as an excuse to abort a child. In pharmacy school, we learned that a child has all the basics of development by the time they're 12 weeks old. We learned many years ago, you may remember something called the thalidomide incident. It was a sedative hypnotic that was given to women when they had the gestation of less than 12 weeks and they ended up having flapping kids. And so then we understood that you shouldn't give any drugs to a developing child until after 12 weeks because the child will be fully developed at that time with a heartbeat, with a brain that's fully developed, maturing of course, but intact. And one thing that my colleague from District 14 mentioned, that the one we're not talking about is the one that's also guaranteed life. Our Constitution guarantees life, liberty, or the pursuit of happiness. So I think the voters of Nevada spoke in 1990 and said that abortion should be a right in this state. And the way you have it here in Nevada is that the only way you can overturn the vote of the people is to go back to the people and vote again if you have changes. But this bill, this amendment, is going to facilitate abortion rights at all months of gestation as a fundamental constitutional right. That's much different than the ballot measure in 1990. It's much more expansive. And like my colleagues have more than articulated, with the advances of technology that we have today, we have infants that are 3 and 4 months that are in our NICUs and are surviving with the full faculties of a healthy human being. So this really goes down to, you know, what is the definition of life? I agree with my colleague that when that heart beats, and especially after 12 weeks when the baby's fully formed, you have a baby. And this is just not me speaking. If you have a pregnant woman that's walking down the street and she's the victim of a drive-by shooter, the district attorney is going to file not one murder charge, but file 2 murder charges. One for the mother and one for the child. So even our laws recognize that an infant 2, 3, 4, 5, 6 months old is a life. And that should be taken into consideration. So my strong concerns for this amendment are the unintended consequences of what we're trying to do here. I think that the citizens that I've spoken to, Democrats, independents, Republicans, moderates, conservatives, liberals, many agree with abortion. But I can tell you that many of them said there's got to be a limit to when you can get that abortion. 24 weeks, which was passed in 1990, is the rule today. And to allow abortion on demand upwards of 9 months, to me is horrific. What the rules are that if the baby being born can live without any extra medicinal attention, equipment, that baby's got to be saved. But if that baby does require some type of medical interventions, equipment, respirators, that baby can be left to expire, which I think is horrific. I also have a strong concern that in Nevada, we don't need parental consent for a child to get an abortion. I think that's fundamentally wrong. And I believe that a majority of people in Nevada agree with that premise, that the parents should be included in that very important decision that child can make. I also worry that young girls are going to be transported into Nevada and get secret abortions and are going to be protected by this amendment. We live in Sin City, okay? We have a lot of things that are legal here that are not legal in other states. And I believe with the passage of this amendment, I think the citizens of the state of Nevada are going to see the arguments that we are going to be having here today. I'm not afraid of it going on the ballot because I believe I have a defense. I have a defense that's going to show that what we're trying to do is not appropriate. And I also believe that we should be doing everything we possibly can to provide help for those that become pregnant and provide options for them. We have people that go to other countries to adopt babies. Why don't they adopt babies in this country? It's because we abort our babies. And I also worry about the targeting of certain populations of people. Where do you see all the Planned Parenthood offices? It's usually in economically distressed, and I will say populations of color that are being targeted. And I think it's very inappropriate that we take advantage of these populations of people. I also believe that by making this a constitutional right, I believe it will be challenged. And I believe it will not sustain that challenge because, again, every human being deserves life, liberty, and the pursuit of happiness. I respectfully disagree with what this amendment is trying to do, and for that reason, I hope that you'll vote no on it. Thank you.
Senator Titus.
Thank you, Mr. President. I absolutely appreciate everybody's comments and my colleagues' heart-filled, emotional responses to this. As a physician who has counseled many patients on their options and choices, I have a unique position. I also will share my experience. When I found myself pregnant, getting divorced, and an intern in my residency, all of my friends said I should get an abortion. I chose not to. And I was so happy with my daughter, who now has given me 2 granddaughters. But again, when I counsel a patient, and when I made my own decision not to get an abortion, they were both my decisions. I won't perform an abortion. Again, my decision. I do not believe any medical decision should be in our Constitution. And as our majority leader spoke out, medical choices should be between the provider and the patient. I have said that all along since I came in this building. Medical decisions should be between the provider and the patient. I have never supported an NRS or any of these bills that we've passed throughout this 5 sessions I've been here that mandates healthcare decisions or choices. And I cannot support SJR 7. Again, we're putting in our Constitution a healthcare decision. Again, as was stated by the very first opening statement here today, we should be not legislating healthcare choices, but yet that's the very thing they want to do in SJR 7. This is wrong. It's wrong for everybody. And please vote no on SJR 7. Thank you.
Senator Scheibel.
Thank you, Mr. President. I don't belabor under the illusion that my comments are going to change the outcome of this vote, but I still felt that it was important to rise in support of SJR 7 and mention something that I don't think we have discussed sufficiently at this point in our debate, which is the existence of non-viable pregnancies, which anybody who has experience in this area, and frankly all of us, should know enough by now, having sat in this legislature long enough to hear bills on health care and reproductive freedom, should know that it's not like a pregnancy test. A pregnancy test tells you whether or not your body is producing the hormones that indicate that there is a pregnancy growing within your uterus. But whether that pregnancy is viable or not is not a positive or negative test. That is an extremely complex analysis made by a medical team. And when that medical team determines that the pregnancy is not viable, the person who is responsible for the well-being of that non-viable fetus is their parent. When somebody is pregnant and that fetus's brain is not growing appropriately, or that fetus has some kind of genetic disformation or abnormality, when doctors can predict that the likelihood of that baby ever taking a breath outside the womb is small, no doctor, no medical professional with 100% certainty can tell any person that their baby will or will not take a breath outside the womb, will or will not live beyond the first hour of their life, will or will not survive in the NICU for 3, 4, 5 days, months, or even years. So who is left to make that decision but the parent? The grieving, confused, astonished parent who has to deal with the reality that a medical professional is telling them that the baby that they wanted so much, the baby that is already on the way, may not live to see its first birthday, may not live to see 1 hour of life, because these are real decisions that real people are making across the country every single day. And when we don't allow them the freedom to make that decision with their doctor, to evaluate those odds, to evaluate those chances, to weigh them against the individual's ability to deal with the possible repercussions of continuing with that pregnancy or discontinuing that pregnancy, we make that decision exponentially harder. And that is not our place as lawmakers It is our place to support our constituents and to provide them with every possible opportunity to create the life that they want to have here in the state of Nevada. And so when it comes to the families in my district who are facing the incredibly difficult choices that come with a pregnancy that is not healthy, that is not viable, that does not look like it will result in a healthy, vibrant, young infant who becomes a child, who becomes an adult, who becomes the parent to their grandchildren, I stand behind those constituents to go to the ballot box and tell us that they want to protect the right to make choices for themselves and their families in that situation and all of the other infinite number of situations that could arise between the time somebody becomes pregnant and becomes a parent. And with that, Mr. President, I would urge all of my colleagues to consider allowing their constituents to voice their concerns, voice their opinions in the same way, and vote yes on SJR 7.
Senator Buck.
Thank you, Mr. President. I rise in opposition today to SJR 7. My second son, midway through my pregnancy, my doctor ran a test and told me that he had spina bifida. I have to tell you that the next few weeks I spent on my knees in prayer. I spent the next 4 weeks praying, and he was born healthy with a little birthmark right on his spine. And so I tell you this because my colleague who said that if you get a negative test or if suddenly something is maybe said that it's not viable, well, a lot of times then they give you something to where you would have the baby early if the brain is not functioning. Yes, that's not what I'm saying. I'm saying if a test comes back and potentially there is a healthy, viable life, why would we not have that? Instead, what we're doing is we're tearing babies apart limb by limb at up to 24 weeks. What are we doing? I rise in opposition to SJR 7 because it is wrong. We treat our pets better than this. Thank you.
Are there any further remarks? Seeing none, the secretary will call the roll. Senator Spearman? Okay, anyone like to change their vote? Seeing none, we will close the roll. The ayes are 13, the nays are 8. The joint resolution, SJR 7, has received a constitutional majority and is declared passed and ordered to the Assembly. Senator Donate, did you have a comment?
Thank you, Mr. President. I just wanted to make a statement on order of business number 9 that I have withdrawn my amendment to Senate Bill 348. Thank you.
Thank you.
That concludes order of business 9.
Okay, we are on order of business 12, second reading.
Senate Bill 42, introduced by Health and Human Services, revises provisions relating to the funding of medical assistance to indigent persons. The people of the state of Nevada, represented in Senate and Assembly, to enact as follows. Section 1 and to Section 1.
Are there any amendments to the bill?
I have amendment number 85.
And who is speaking on this? Oh, you have to push her. There you go. Your button's not. There we go. Senator Donate.
Thank you, Mr. President. I move to dispense with the reading of the amendment.
Thank you. If there are no objections, so ordered. Senator Donate.
Thank you, Mr. President. I move to adopt amendment number 85 to Senate Bill 42.
Thank you. Senator Donate.
Amendment 85 to Senate Bill 42 allows contributions to any program approved by any other program by the Federal Centers for Medicare and Medicaid Services of the United States Department of DHHS rather than the state plan.
Are there any further remarks from the floor? Seeing none, all those in favor signify by saying aye. Opposed, nay. Motion carries. Senate Bill 42 is ordered reprinted, engrossed, and to the general file.
Senate Bill 88, introduced by Natural Resources, requires the Joint Interim Committee on Natural Resources to conduct an interim study of certain state agencies. The people of the state of Nevada, represented in Senate Assembly, to enact as follows. Section 1 under Section 1.
Are there any amendments to the bill?
There are not.
SB 88 is ordered to the general file.
Senate Bill 109, introduced by Senator Nguyen, revises provisions governing anatomical gifts. The people of the state of Nevada, represented in Senate Assembly, to enact as follows. Section 1 and to Section 1.
Senator Donate?
Thank you, Mr. President. I move to dispense with the reading of the amendment.
If there are no objections, so ordered. Senator Donate?
Thank you, Mr. President. I move to adopt amendment number 82 to Senate Bill 109.
I've heard the motion. Senator Donate?
Thank you, Mr. President. Amendment 82 satisfies the concerns regarding the process for the coroner or medical examiner to authorize an anatomical gift if there is no evidence that the deceased did not want to be a donor and being held liable for their decision. It adds additional coroner or medical examiner provisions, removes criminal and civil liability for any act or omission with respect to complying with the provisions of this bill, and replaces language of who has the authority to dispose the decedent's body.
Any further remarks from the floor? Seeing none, all those in favor signify by saying aye. Opposed, nay. Motion carries. SB 109 as amended is ordered, reprinted, engrossed, and to the general file.
Senate Bill 172, introduced by Senators Harris, Scheibel, Donate, Orenshaw, and Pazina, revises provisions governing the ability of a minor to consent to certain health care services. The people of the state of Nevada, represented in Senate Assembly, to enact as follows. Section 1 and to Section 1.
Is there an amendment to the bill?
I have amendment number 166.
Thank you, Senator Nguyen.
Thank you, Mr. President. I move to dispense with the reading of Amendment 166.
If there are no objections, so ordered. Senator Nguyen.
Thank you, Mr. President. I move to adopt Amendment 166 to Senate Bill 172.
Thank you. You've heard the motion. Senator Nguyen.
The amendment revises language to Section 1 to clarify that a minor may give express consent for the services named in the bill.
Any further remarks from the floor? Seeing none, all those in favor signify by saying aye. Opposed, nay. Motion carries. SB 172 as amended is ordered, reprinted, engrossed, and to the general file.
Senate Bill 174, introduced by Senators Hammond, Neal, Goycochea, Orenshaw, and Stone, and Assemblyman Gurr, revises provisions governing common interest communities. The people of the state of Nevada, represented in Senate Assembly, to enact as follows. Section 1 and to Section 1.
Are there any amendments to the bill?
I have amendment number 207.
Thank you, Senator Hammond.
Thank you, Mr. President. I move to dispense with the reading of the amendment.
If there are no objections, so ordered. Senator Hammond.
I move to adopt Amendment 207 to Senate Bill 174.
You've heard the motion. Senator Hammond.
Thank you, Mr. President. Amendment 207, the amendment provides that an association manager may process all pre-collection notices, courtesy notices, intent to liens, and other mailings prior to a notice of delinquent assessment being processed.
Any other remarks from the floor? Seeing none, all those in favor signify by saying aye. Opposed, nay. Motion carries. SB 174 as amended is ordered, reprinted, engrossed, and to the general file.
Senate Bill 176, introduced by Senator Goycochea, establishes provisions relating to the conservation of groundwater. The people of the state of Nevada, represented in Senate Assembly, to enact as follows. Section 1 and to Section 1.
Are there any amendments to the bill?
I have amendment number 79.
Thank you. Senator Pazina.
Thank you, Mr. President. I move to dispense with the reading of the amendment.
If there are no objections, so ordered. Senator Pazina.
Thank you, Mr. President. I move to adopt amendment number 79 to Senate Bill 176.
You've heard the motion. Senator Pazina.
Thank you, Mr. President. Amendment 79 to Senate Bill 176 provides that the account for purchasing and retiring water rights shall be administered by the Director of the State Department of Conservation and Natural Resources instead of the state engineer. It establishes the Nevada Water Buyback Initiative to be administered by the Nevada Conservation and Recreation Program. It creates the Advisory Committee for the Nevada Water Buyback Initiative to consult with the Director, changes the term withdrawn to retired throughout the bill and provides other clarifying language, requires the Director to adopt necessary regulations by July 1, 2025, deletes Sections 7 and 8 of the bill, and provides language in Section 9 to clarify that the appropriation is for the reasonable costs incurred by the Director and the Nevada Conservation and Recreation Program in administering the Nevada Water Buyback Initiative and for the purchase of water rights pursuant to Section 6 of the bill.
Are there any further remarks from the floor? Seeing none, all those in favor signify by saying aye. Opposed, nay. Motion carries. SB 176 as amended is ordered reprinted, engrossed, and to the general file.
Senate Bill 232, introduced by Senators Cannizzaro, et cetera, and Assemblywoman Gorlow, requires the state plan for Medicaid to include coverage for postpartum care services. The people of the state of Nevada, represented in Senate and Assembly, do enact as follows. Section 1 and to Section 1.
Are there any amendments to the bill?
I have amendment number 63.
Thank you. Senator Donate.
Thank you, Mr. President. I move to dispense with the reading of the amendment.
If there are no objections, so ordered. Senator Donate.
Thank you, Mr. President. I move to adopt amendment number 63 to Senate Bill 232.
You've heard the motion. Senator Donate.
Thank you, Mr. President. The amendment updates the definition of postpartum services to include medical care that is consistent with the current standards of care. Additionally, the amendment updates their services that should be included in a comprehensive postpartum care visit.
Are there any other remarks on the motion? Seeing none, all those in favor signify by saying aye. Opposed, nay. Motion carries. SB 232 as amended is ordered reprinted, engrossed, and to the general file.
Senate Bill 241, introduced by Senators Titus, Goycochea, Hansen, and Krasner, and Assemblyman Hafen and Koenig, revises provisions relating to Medicaid. The people of the state of Nevada, represented in Senate and Assembly, do enact as follows. Section 1 and to Section 1.
Are there any amendments to the bill?
There are none.
SB 241 is ordered to the general file.
Senate Bill 297, introduced by Health and Human Services, provides for the establishment of the Nevada Memory Network. The people of the state of Nevada, represented in Senate and Assembly, do enact as follows. Section 1 and to Section 1.
Are there any amendments to the bill?
I have amendment number 87.
Thank you. Senator Donate.
Thank you, Mr. President. I move to dispense with the reading of the amendment.
If there are no objections, so ordered. Senator Donate.
Thank you, Mr. President. I move to adopt amendment number 87 to Senate Bill 297.
You've heard the motion. Senator Donate.
Thank you, Mr. President. This amendment replaces the term community-based dementia care navigators with community health workers that specialize in dementia.
Are there any further remarks from the floor? Seeing none, all those in favor signify by saying aye. Opposed, nay. Motion carries. SB 297 as amended is ordered reprinted, engrossed, and to the general file.
Senate Bill 311, introduced by Senators Hansen, Titus, Goycochea, and Flores, revises provisions relating to wildlife. The people of the state of Nevada, represented in Senate and Assembly, do enact as follows. Section 1 and to Section 1.
Are there any amendments to the bill?
There are none.
SB 311 is ordered to the general file.
Senate Bill 316, introduced by Senators Scheibel, Spearman, Harris, Wynn, and Orenshaw, makes various changes relating to criminal law. The people of the state of Nevada, represented in Senate and Assembly, do enact as follows. Section 1 and to Section 1.
Are there any amendments to the bill?
I have amendment number 205.
Senator Scheibel.
Thank you, Mr. President. I move to dispense with the reading of Amendment 205 to Senate Bill 316.
If there are no objections, so ordered. Senator Scheibel.
I move to adopt Amendment 205 to Senate Bill 316.
You've heard the motion. Senator Scheibel.
The amendment transfers the submittal of reports and the duties associated with those reports from the Attorney General to the Nevada Department of Sentencing Policy.
Are there any further remarks from the floor? Seeing none, all those in favor signify by saying aye. Opposed, nay. Motion carries. SB 316 as amended is ordered reprinted, engrossed, and to the general file.
Senate Bill 317, introduced by Senators Scheibel, Spearman, Danyate, Neal, Harris, Daley, Lang, Orenshaw, and Pazina, establishes provisions relating to resources for persons experiencing homelessness. The people of the state of Nevada, represented in Senate and Assembly, to enact as follows. Section 1 and to Section 1.
Are there any amendments to the bill?
I have amendment number 235.
Thank you. Senator Donate.
Thank you, Mr. President. I move to dispense with the reading of the amendment.
If there are no objections, so ordered.
Thank you, Mr. President. I move to adopt the amendment.
You've heard the motion. Senator Donate.
Amendment 235 to Senate Bill 317 does the following. It removes the definition of a Nevada resident as an individual who has resided in the state for at least 6 months or has a Nevada's driver's license, and adds that nothing in this provision precludes a person who is residing at a provider of homeless services or experiencing homelessness from using the address at their residence for the purposes of registering to vote or obtaining voting materials by mail.
Thank you. Are there any further remarks from the floor? Seeing none, all those in favor signify by saying aye. Opposed, nay. Motion carries. SB 317 as amended is ordered reprinted, engrossed, and to the general file.
Senate Bill 350, introduced by Senators Pazina, et cetera, and Assemblyman C.H. Miller, revises provisions relating to graduate medical education. The people of the state of Nevada, represented in Senate and Assembly, to enact as follows. Section 1 and to Section 1.
Are there any amendments to the bill?
I have amendment number 135.
Senator Donate.
Thank you, Mr. President. I move to dispense with the reading of the amendment.
If there are no objections, so ordered. Senator Donate.
Thank you, Mr. President. I move to adopt amendment number 135 to Senate Bill 350.
You've heard the motion. Senator Donate.
Thank you, Mr. President. Amendment 135 updates the study requirements for the Advisory Council on Graduate Medical Education to include the retention and recruitment of physicians. It establishes the frequency and how often the council should meet and requires any remaining balance for the appropriation awarded to be reverted to the Graduate Medical Education Grant Program for additional expenditures.
Thank you. Are there any further remarks from the floor? Seeing none, all those in favor signify by saying aye. Opposed, nay. Motion carries. SB 350 as amended is ordered reprinted, engrossed, and to the general file.
Senate Bill 368, introduced by Senators Harris, et cetera, revises provisions relating to real property. The people of the state of Nevada, represented in Senate and Assembly, to enact as follows. Section 1 and to Section 1.
Are there any amendments to the bill?
I have amendment number 164.
Senator Wynn.
Thank you, Mr. President. I move to dispense with the reading of the amendment.
If there are no objections, so ordered.
Thank you, Mr. President. I move to adopt the amendment.
You've heard the motion. Senator Wynn.
Amendment 164 requires a district court that determines that a restriction or prohibition is void and unenforceable to issue an order directing the county recorder to record free of charge a restrictive covenant modification form and redact the restriction of or prohibition from all future versions of the written instrument.
Thank you. Any further remarks from the floor? Seeing none, all those in favor signify by saying aye. Opposed, nay. Motion carries. SB 368 as amended is ordered reprinted, engrossed, and to the general file.
Senate Bill 387, introduced by Senator Pazina, revises provisions related to the state personnel system. The people of the state of Nevada, represented in Senate and Assembly, to enact as follows. Section 1 and to Section 1.
Are there any amendments?
There are none.
SB 387 is ordered to the general file.
Senate Bill 416, introduced by Judiciary, revises provisions relating to the Department of Corrections. The people of the state of Nevada, represented in Senate and Assembly, to enact as follows. Section 1 and to Section 1.
Are there any amendments?
There are none.
SB 416 is ordered to the general file.
Senate Bill 428, introduced by Senators Flores, et cetera, and Assemblyman De Silva, et cetera, proposes to exempt sales of diapers from sales and use taxes and analogous taxes upon approval by the voters. People of the state of Nevada, represented in Senate and Assembly, to enact as follows. Section 1 and to Section 1.
Are there any amendments?
There are none.
SB 428 is ordered to the general file.
That concludes Order of Business 12.
Order of Business 13, general file. Senator Dondero-Loop.
Thank you, Mr. President. May we go to order of business number 9?
Yes. Okay. We are on order of business number 9.
Thank you. I move that Senate bills numbers 88, 176, 232, 241, 297, 311, 350, 387, 416, and 428 be taken from their positions on general file and referred to the Committee on Finance upon return from reprint. Thank you.
If there are no objections, so ordered. Thank you. Now we are back on Order Business 13, General File.
Senate Bill 223, introduced by Senator Harris, revises provisions relating to real property. The people of the state of Nevada, represented in Senate and Assembly, to enact as follows: Section 1 and to Section 1.
Are there any amendments to the bill?
There are none. Section 17, this act becomes effective on July 1, 2023. End of bill.
Are there any remarks from the floor? Senator Scheibel.
Thank you, Mr. President. Senate Bill 223 makes various revisions relating to real property, including but not limited to clarifying that a notice of pendency of an action or withdrawal or cancellation of such must be filed with the recorder of each county where any of the property is located. It similarly clarifies that documents relating to a foreclosure or a trustee's sale must be recorded in each county where any of the property is located. The bill also clarifies certain instances when a lien must be recorded and exempts the property of a seller who, after a sale, becomes a tenant of the same property for 90 days or less from the provisions of the Residential Landlord and Tenant Act. Finally, the bill provides that a real estate broker's claim for a commission is satisfied when an escrow agent who has reserved from an owner's net proceeds an amount equal to the amount claimed by the broker in his or her recorded claim deposits that amount with the district court, thus removing the escrow agent from any further involvement with such a claim.
Thank you. Are there any further remarks? Seeing none, the secretary will open the roll. Anyone wish to change their vote? Seeing none, the secretary will close the roll. The vote is 21 yea, 0 nay. SB 223 has received the constitutional majority and is declared passed and ordered to the Assembly.
That concludes Order of Business 13 and the business of the desk for the second agenda.
Thank you. We're now on Order of Business 16, remarks from the floor, introduction of guests. Senator Hansen.
Thank you, Mr. President. I just want a correction on something I said earlier in the day when we were discussing the gun bills. I said there was 145 minutes of testimony for the proponents. That was incorrect. It was 1 hour and 45 minutes. Just want to get that in the record. Thank you.
Thank you. Any other remarks from the floor? Introduction of guests. All right, seeing none, we will now go on to the third agenda of the day. We are on Order of Business 10, introduction, first reading, and reference.
Senate Bill 451, introduced by Senator Spearman, enacts provisions to promote the development and use of clean hydrogen technology in this state. End of bill.
Very good. Order of Business 8, waivers and exemptions. Oh. Okay, I didn't see that. Okay, we are still on Order of Business 10. Senator Spearman, did you have a motion?
Sir, just a minute. Thank you, Mr. President. Move to refer Senate Bill 451 to the Committee on Growth and Infrastructure.
Thank you. If there are no objections, so ordered. Okay, now we are on Business 8, waivers and exemptions.
Waiver of joint standing rules, a waiver requested by Senator Cannizzaro for Senate Bill 451 to waive subsection 1 of joint standing rule number 14.2 and subsections 1, 2, 3, and 4 of joint standing rule number 14.3 has been granted effective March 27, 2023, signed Senator Nicole Cannizzaro, Senate Majority Leader, and Assemblyman Steve Yeager, Speaker of the Assembly. End of waiver.
Thank you. Order of Business 12, second reading.
Senate Bill 41, introduced by Health and Human Services, revises provisions relating to child welfare. The people of the state of Nevada, represented in Senate and Assembly, to enact as follows: Section 1 and to Section 1.
Are there any amendments to the bill?
I have amendment number 86.
Thank you. Senator Donate.
Thank you, Mr. President. I move to dispense with the reading of the amendment.
If there are no objections, so ordered. Senator Donate.
Thank you, Mr. President. I move to adopt amendment number 86 to Senate Bill 41.
You've heard the motion. Senator Donate.
Thank you, Mr. President. Amendment 86 to Senate Bill 41 provides authority for the state to administer the grant as a categorical annual grant instead of an incentive grant. Base this process on the fiscal year rather than the calendar year. Change the timeline of reporting the progress made to each agency to the governor and the legislature to 60 days from year end after the submission, and adds factors and additional topics to be addressed and studied by the 2023-2024 Joint Interim Committee on Health and Human Services.
Thank you. Are there any remarks from the floor? Seeing none, all those in favor signify by saying aye. Opposed, nay. Motion carries. SB 41 as amended is ordered reprinted, engrossed, and to the general file.
Senate Bill 81, introduced by Senator Daley, revises provisions governing regional planning. The people of the state of Nevada, represented in the Senate Assembly, to enact as follows: Section 1 and to Section 1.
Are there any amendments to the bill?
I have amendment number 156.
Senator Flores.
Thank you, Mr. President. I move to dispense with the reading of amendment number 156.
Are there any objections? If not so ordered, Senator Flores.
Thank you, Mr. President. I move for the adoption of amendment 156 to Senate Bill 81.
You've heard the motion, Senator Flores.
Thank you, Mr. President. Amendment 156 adds certain state agencies and school districts to the list of agencies that local governments may consult with and solicit input concerning certain requirements, and it requires that the majority leader of the state Senate and the Speaker of the Assembly to each appoint 2 members of their respective houses, one from the majority party and one from the minority party. It clarifies that each legislative member and each city manager serves in ex officio capacity, and requires the joint regional report to be prepared and approved by the majority of the county managers.
Are there any remarks from the floor? Seeing none, all those in favor signify by saying aye. Opposed, nay. Motion carries. SB 81 as amended is ordered reprinted, engrossed, and to the general file.
Senate Bill 115, introduced by Senator Flores, revises provisions relating to the mitigation of certain projects. The people of the state of Nevada, represented in Senate Assembly, to enact as follows: Section 1 and to Section 1.
Are there any amendments to the bill?
I have amendment number 157.
Senator Flores.
Thank you, Mr. President. I move to dispense with the reading of amendment number 157.
Are there any objections? If not so ordered, Senator Flores.
Thank you, Mr. President. I move for the adoption of amendment number 157 to Senate Bill 115.
You've heard the motion, Senator Flores.
Thank you, Mr. President. Amendment 157 clarifies the application of certain federal regulations regarding an ordinance establishing a mitigation bank or an in-loop fee program.
Are there any remarks from the floor? Seeing none, all those in favor signify by saying aye. Opposed, nay. Motion is carried. SB 115 as amended is ordered reprinted, engrossed, and to the general file.
Senate Bill 117, introduced by Health and Human Services, revises provisions relating to community health workers. The people of the state of Nevada, represented in Senate Assembly, to enact as follows: Section 1 and to Section 1.
Are there any amendments to the bill?
I have amendment number 232.
Senator Donate.
Thank you, Mr. President. I move to dispense with the reading of the amendment.
Are there any objections? If not so ordered. Senator Donate.
Thank you, Mr. President. I move to adopt amendment number 232 to Senate Bill 117.
You've heard the motion, Senator Donate.
Thank you, Mr. President. This amendment removes the provisions relating to community health workers that state a person shall not hold himself or herself as a CHW, and poses civil penalties for a person who violates.
Are there any remarks from the floor? Seeing none, all those in favor signify by saying aye. Opposed, nay. Motion carries. SB 117 as amended is ordered reprinted, engrossed, and to the general file.
Senate Bill 145, introduced by Senators Lang, Dunyate, Daley, and Orenshaw, revises provisions related to employee misclassification. The people of the state of Nevada, represented in Senate Assembly, to enact as follows: Section 1 and to Section 1.
Are there any amendments to the bill?
I have amendment number 95.
Thank you. Senator Spearman.
Thank you, Mr. President. I move to dispense with the reading of the amendment.
Are there any objections? So ordered.
Thank you, Mr. President. I move that the Senate adopt amendment number 95 to Senate Bill 145.
You've heard the motion, Senator Spearman.
Amendment 95 to Senate Bill 145 does the following. Requires that administrative penalties imposed by the Labor Commissioner include issuing a warning to an employer for the first offense of misclassifying or otherwise failing to properly classify a person as an employee, and a $5,000 fine for a second or subsequent offense of willfully misclassifying an employee.
Are there any remarks from the floor? Seeing none, all those in favor signify by saying aye. Opposed, nay. Motion carries. SB 145 as amended is ordered reprinted, engrossed, and to the general file.
Senate Bill 166, introduced by Senators Pizzina, Daley, Dondero, Loop, and Wynn, and Assemblyman Hibbets and Urick, revises provisions relating to collective bargaining by public employees. The people of the state of Nevada, represented in Senate and Assembly, do enact as follows. Section 1 into Section 1.
Are there any amendments to the bill?
I have amendment number 158.
Senator Flores.
Thank you, Mr. President. I move to dispense with the reading of Amendment 158.
Are there any objections? So ordered. Senator Flores.
Mr. President, I move that we adopt Amendment 158 to Senate Bill 166.
You've heard the motion. Senator Flores.
Mr. President, Amendment 158 provides for separate bargaining units for supervisory employees who are Category 1, Category 2, and Category 3 peace officers, and supervisory employees who are firefighters.
Are there any remarks from the floor? Seeing none, all those in favor signify by saying aye. Opposed, nay. Motion carries. SB 166 as amended is ordered reprinted, engrossed, and to the general file.
Senate Bill 167, introduced by Senators Dondero, Loop, etc., and Assemblywoman Thomas, prohibits the imposition of step therapy under certain circumstances. The people of the state of Nevada, represented in Senate and Assembly, do enact as follows. Section 1 into Section 1.
Are there any amendments to the bill?
I have amendment number 104.
Senator Spearman.
Thank you, Mr. President. I move to dispense with the reading of the amendment.
Are there any objections? So ordered.
Thank you, Mr. President. I move that the Senate adopt Amendment number 104 to Senate Bill 167.
You've heard the motion. Senator Spearman.
Amendment 104 to Senate Bill 167 does the following. It extends the list of prescribing practitioners to include specific medical professionals, adds a subsequent defining step therapy protocol, and replaces provisions to prohibit health plans from requiring step therapy for Food and Drug Administration approved psychiatric drugs or drugs backed by medical or scientific evidence if a prescribing practitioner deems that the required drugs ineffective based on the medical history of the insured.
Are there any remarks from the floor? Seeing none, all those in favor signify by saying aye. Opposed, nay. Motion carries. SB 167, as amended, is ordered reprinted, engrossed, and to the general file.
Senate Bill 203, introduced by Senator Iñate, prohibits certain gifts by a manufacturer or wholesaler of drugs or medical devices to a practitioner. The people of the state of Nevada, represented in Senate and Assembly, do enact as follows. Section 1 into Section 1.
Are there any amendments to the bill?
I have amendment number 154.
Senator Spearman.
Thank you, Mr. President. I move to dispense with the reading of the amendment.
Are there any objections? So ordered.
Thank you, Mr. President. I move that the Senate adopt Amendment number 154 to Senate Bill 203.
You've heard the motion. Senator Spearman.
Amendment 154 to Senate Bill 203 does the following. Revises the term, quote, gift, end quote, to exclude modest meals and refreshments provided in informational communication settings. It deletes proposed annual reporting requirements and adds provisions requiring the State Board of Pharmacy to post a link to publicly available information through the Federal Open Payments website concerning any gift provided to the practitioner by a manufacturer on its internet website, and deletes provisions concerning confidentiality of certain information.
Are there any remarks from the floor? Seeing none, all those in favor signify by saying aye. Opposed, nay. Motion carries. SB 203, as amended, is ordered reprinted, engrossed, and to the general file.
Senate Bill 208, introduced by Senators Flores, Stone, Goycochea, Daley, Krasner, and Orenshaw, authorizes counties and cities to enact certain ordinances relating to battery-charged fences. The people of the state of Nevada, represented in Senate and Assembly, to enact as follows. Section 1 into Section 1.
Are there any amendments?
I have amendment number 160.
Thank you, Senator Spearman. Oh, I'm sorry, your light was still on. Senator Flores.
Thank you, Mr. President. I move to dispense with the reading of Amendment number 160.
Are there any objections? So ordered. Senator Flores.
Thank you, Mr. President. I move for the adoption of Amendment 160 to Senate Bill 208.
You've heard the motion. Senator Flores.
Amendment 160 changes may to shall to require the governing body of a county or city to enact an ordinance related to battery charge fences.
Are there any remarks from the floor? Seeing none, all those in favor signify by saying aye. Opposed, nay. Motion carries. SB 208, as amended, is ordered reprinted, engrossed, and to the general file.
Senate Bill 237, introduced by Health and Human Services, revises provisions relating to crisis intervention. The people of the state of Nevada, represented in Senate and Assembly, to enact as follows, Section 1 into Section 1.
Are there any amendments?
I have amendment number 83.
Thank you. Senator Donate.
Thank you, Mr. President. I move to dispense with the reading of the amendment.
Are there any objections? So ordered. Senator Donate.
Thank you, Mr. President. I move to adopt amendment number 83 to Senate Bill 237.
You've heard the motion. Senator Donate.
Thank you, Mr. President. This amendment retains the authority to assess the surcharge with the State Board of Health, thereby allowing the board to promulgate regulations and adjust the surcharge. It adds that the surcharge is to be remitted to the division before the end of each month, requires relevant companies to report information to the department, removes sections 2 and 3, and clarifies that the surcharge can be used for crisis stabilization centers.
Are there any remarks from the floor? Seeing none, all those in favor signify by saying aye. Opposed, nay. Motion carries. SB 237, as amended, is ordered reprinted, engrossed, and to the general file.
Senate Bill 239, introduced by Senators Flores, et cetera, and Assemblywoman Torres, et cetera, establishes provisions governing the prescribing, dispensing, and administering of medication designed to end the life of a patient. The people of the state of Nevada, represented in Senate and Assembly, to enact as follows, Section 1 into Section 1.
Are there any amendments?
I have amendment number 84.
Thank you. Senator Donate.
Thank you, Mr. President. I move to dispense with the reading of the amendment.
Are there any objections? So ordered. Senator Donate.
Thank you, Mr. President. I move to adopt the amendment 84 to Senate Bill 239.
You've heard the motion. Senator Donate.
Thank you, Mr. President. This amendment authorizes a coroner or its deputy to investigate these deaths, but does not require them to. Additionally, it adds language that protects local government, coroners, and law enforcement employees from the civil and criminal penalties for investigating these deaths. It clarifies that the manner of death cannot be indicated as suicide, replaces the term mental competence with mental capacity, removes a section defining PAs as practitioners, excluding PAs from being able to prescribe the end-of-life drug, and adds a new section that excludes deaths resulting from exercising the provisions of this bill from the definition of a suicide.
Are there any remarks on the floor? Seeing none, all those in favor signify by saying aye. Opposed, nay. Motion carries. SB 239, as amended, is ordered reprinted, engrossed, and to the general file.
Senate Bill 249, introduced by Senators Lang, et cetera, and Assemblyman Nguyen, revises provisions relating to cosmetology. The people of the state of Nevada, represented in Senate and Assembly, to enact as follows, Section 1 into Section 1.
Are there any amendments?
I have amendment number 103.
Senator Spearman.
Thank you, Mr. President. Move to dispense with the reading of the amendment.
Are there any objections? So ordered.
Thank you, Mr. President. I move that the Senate adopt amendment number 103 to Senate Bill 249.
You've heard the motion. Senator Spearman.
Amendment 103 to Senate Bill 249 does the following. It deletes Section 1, which would have allowed registered nurses to perform non-ablative aesthetic medical procedures under supervision. It increases the time frame for citation receipt by mail from 3 to 7 days, requires the Executive Director of the State Board of Cosmetology to obtain board approval for establishing additional office locations, mandates 4 years of documented practice in a location that the board or its designee deems acceptable for various licenses, and requires displaying licenses or certificates wherever a cosmetologist is practicing in public.
Are there any remarks from the floor? Seeing none, all those in favor signify by saying aye. Opposed, nay. Motion carries. SB 249, as amended, is ordered reprinted, engrossed, and to the general file.
Senate Bill 270, introduced by Senator Scheibel, revises provisions governing massage therapists. The people of the state of Nevada, represented in Senate and Assembly, to enact as follows, Section 1 into Section 1.
Are there any amendments to the bill?
I have amendment number 102.
Senator Spearman.
Thank you, Mr. President. Move to dispense with the reading of the amendment.
Are there any objections? Seeing none, so ordered.
Thank you, Mr. President. Move that the Senate adopt amendment number 102 to Senate Bill 270.
You heard the motion, Senator Spearman.
Thank you. Amendment 102, Senate Bill 270 does the following. It corrects language referencing, quote, active military member, end quote, to keep provisions within the Interstate Massage Compact identical.
Are there any remarks from the floor? Seeing none, all those in favor signify by saying aye. Opposed, nay. Motion carries. SB 283, as amended, is ordered reprinted, engrossed, and to the general file. Oh, I'm sorry. Did I say 283? Okay. SB 270, as amended, is ordered reprinted, engrossed, and to the general file.
Senate Bill 283, introduced by Senators Pazina, et cetera, revises certain provisions relating to health care records. The people of the state of Nevada, represented in Senate and Assembly, to enact as follows, Section 1 and Section 1.
Are there any amendments?
I have amendment number 100.
Senator Spearman.
Thank you, Mr. President. Move to dispense with the reading of the amendment.
Are there any objections? So ordered.
Thank you, Mr. President. Move that the Senate adopt amendment number 238 to Senate Bill 381.
You've heard the motion, Senator Spearman.
Amendment 238 to Senate Bill 381 does the following. It authorizes landlords to charge tenants for repairs or maintenance resulting from tenants' negligence, deliberate acts, or those others on the premises with the tenant's consent.
Senator Spearman, we need to go back to SB 283.
Oh, yeah.
I think you made a motion on a different. So.
You're right, sir. I jumped the gun.
So we'll continue on, Senator Spearman, on SB 283, amendment number 100.
Thank you, Mr. President. Move to dispense with the reading of the amendment.
Are there any objections?
Thank you. I move that the Senate adopt amendment number 100 to Senate Bill 283.
Thank you. You've heard the motion, Senator Spearman.
Amendment 100 to Senate Bill 283 does the following. It deletes references and applicability to a person who owns or operates an ambulance, includes third-party administrators, requires electronic transmission of occupational injury, disease records, and allows up to $15 fee for providing electronic health records.
Are there any further remarks from the floor? Seeing none, all those in favor signify by saying aye. Opposed, nay. Motion carries. SB 283, as amended, is ordered reprinted, engrossed, and to the general file.
Senate Bill 380, introduced by Senator Wynn, revises provisions relating to the Extended Young Adult Support Services Program. The people of the state of Nevada, represented in Senate and Assembly, to enact as follows, Section 1 and Section 1.
Are there any amendments to the bill?
I have amendment number 134.
Senator Spearman. Okay, your light's off. So who wants to? Oh, Senator Donate, yes.
Thank you, Mr. President. I move to dispense with the reading of the amendment.
Are there any objections? So ordered. Senator Donate.
Thank you, Mr. President. I move to adopt amendment number 134 to Senate Bill 380.
You've heard the motion, Senator Donate.
Thank you, Mr. President. This amendment adds the definition of the terms young adult and kinship, guardianship, assistant program, and updates the reporting requirements from the Division of Child and Family Services of the Department of Health and Human Services.
Are there any remarks from the floor? Seeing none, all those in favor signify by saying aye. Opposed, nay. Motion carries. SB 380, as amended, is ordered reprinted, engrossed, and to the general file.
Senate Bill 381, introduced by Senators Harris, et cetera, prohibits a landlord from requiring a tenant to pay certain charges. The people of the state of Nevada, represented in Senate and Assembly, to enact as follows, Section 1 and Section 1.
Are there any amendments to the bill?
I have amendment number 238.
Senator Spearman.
Thank you, Mr. President. Move to dispense with the reading of the amendment.
Are there any objections? So ordered.
Thank you, Mr. President. I move that the Senate adopt Amendment 238 to Senate Bill 381.
You've heard the motion, Senator Spearman.
It authorizes Senate Bill Amendment number 238 to Senate Bill 381 does the following. It authorizes landlords to charge tenants for repairs or maintenance resulting from tenants' negligent, deliberate acts, or those of others on the premises with the tenant's consent.
Are there any remarks from the floor? Seeing none, all those in favor signify by saying aye. Opposed, nay. Motion carries. SB 381, as amended, is ordered reprinted, engrossed, and to the general file.
That concludes Order Business 12 and the business of the desk for this legislative day.
Okay, we're on 16, remarks from the floor, introduction of guests. We have another one? Okay, we're not on order of business 16. Senator Dondero Loop.
Thank you, Mr. President. That probably stopped me from saying anything smart. May we go to order of business 9, please?
Sure, let's go to order of business 9.
Thank you, Mr. President. I move the Senate bills numbers 41, 145, 166, 167, 237, and 380 be taken from their positions on general file and re-referred to the Committee on Finance. Thank you.
Thank you. Are there any objections? So ordered.
That concludes order of business 9 and the business of the desk for the
All
Saturday.
right. Order of business 16, remarks from the floor, introduction of guests. All right, Senator Cannizzaro.
Thank you, Mr. President. Before we get to an adjournment, I know those of us who have been in this body for a while or who've had the opportunity to serve on finance have had the opportunity to work with one of our really wonderful finance folks, Alex Hartz. And it is, as my understanding, his birthday today. So I wanted to let all of us and he has joined us out of retirement, which we're very thankful for, his wealth of knowledge and willingness to continue to come and help serve us. So if the body would please join me in wishing him a very, very happy birthday, I would appreciate it. He's in the back in case you missed him or don't know. But he's wonderful and fabulous and great to work with. So happy birthday. With that, Mr. President, I would move that the Senate stand in adjournment until the hour of 3:30 p.m. on Tuesday, April 18th, 2023.
All right, you heard the motion. All those in favor signify by saying aye. Opposed, nay. Motion carries. We are adjourned.